What kind of property is protected in a Virginia bankruptcy? There's an idea that someone who files bankruptcy ends up losing all their property, and that's just not true. In fact, the vast majority of Chapter 7 cases, liquidation cases, are what we call no asset cases, meaning there are no assets of consequential value that are not protected that can be sold by the trustee. And the person who files bankruptcy still receives a discharge of his or her dischargeable debts, even though in that Chapter 7 case there was no property to be sold. Now, the first issue in deciding what kind of property can be protected in bankruptcy is which exemptions apply to this particular debtor and his or her property. The Bankruptcy Code is federal law, but it's administered in the 50 states of the United States. Each state has the option of either accepting a specific set of bankruptcy exemptions, which are laws that protect certain types of property. They're exempt from creditor process. Each state can either accept the federal bankruptcy exemptions or provide the citizens of its state with its own state law exemptions to use in bankruptcy. That second category of states, those are known as the opt-out states. They've opted out of the federal set of bankruptcy exemptions, and Virginia is in that set. Virginia has opted out. Now, that doesn't necessarily mean that someone who files bankruptcy in Virginia uses the Virginia exemptions. In fact, in 2005, the Bankruptcy Code was changed by Congress to prevent forum shopping, which is where a debtor goes and moves to a state where he or she can protect the most property. There are some states, for instance, that give an unlimited homestead exemption, so somebody who owns a very valuable home, their house is protected in bankruptcy from creditors. To prevent that from happening, the Bankruptcy Code was changed to provide for a look-back period when determining whether the state exemptions or the federal bankruptcy exemptions would apply, or which state's exemptions would apply. That's a 730-day period. So you look back 730 days before the filing date and determine if the debtor lived in a single place. If that was the debtor's domicile for that 2-year period, that's the state whose exemptions govern which kind of property can be protected in bankruptcy. If there was more than one domicile within that 2-year look-back period, then you look back another 6 months, 180 days, and determine for the greater portion of that 180 days in what domicile did the debtor have. And that's the state whose exemption laws will control. Now, if somebody doesn't qualify for the Virginia exemptions, it may be that they have to use a different state, or they may qualify for the federal bankruptcy exemption. Some states are either-or states. You can use the state law or the federal set of bankruptcy exemptions. Some are opt-out states. You're only supposed to use the state and not the specific bankruptcy exemptions in the Bankruptcy Code. Someone shouldn't be left with any exemptions. In that case, in a default case, the federal exemptions, the Bankruptcy Code exemptions should apply. So after we've determined what state law is going to govern which domicile, there's some particular types of property that are protected from creditors. One is a tenancy by the entirety with the common law right of survivorship. This is a special kind of tenancy in Virginia and other states that's based on the old legal fiction that a husband and wife are a single person, and therefore the debts of either one of them alone do not attach to the property. The only exception to that is the IRS. As a supercreditor, the IRS can attach to tenants by the entirety property when only one spouse is liable. Otherwise, for other creditors, both spouses must be on the hook for that debt, in order for their property to be subject to attachment to a debt. Another type of property that's protected in bankruptcy are qualified retirement funds. These are the most common types of retirement plans and funds that are set up according to IRS guidelines. ERISA funds would be an example. They're set up under various sections of the IRS code, usually in the 400s. Now, in addition to those, the main two sets of exemptions in Virginia are the poor debtors exemptions and the homestead exemptions. The poor debtors exemptions are sort of a laundry list of different types of property that is protected from creditors, some without regard to the value, and others within certain limits. And a debtor who files bankruptcy in Virginia and is using the Virginia exemptions can claim, for instance, up to $5,000 worth of household furnishings, up to $6,000 in a motor vehicle, up to $3,000 in a firearm, up to $10,000 in occupational tools, machinery, equipment necessary for use in their trade or occupation. And when we're looking at the value of the property, it's the value of the property of not to replace it with new, but similar age and condition. In most cases, that would be a garage sale or yard sale value if you drag the stuff out to the curb or sold it on Craigslist or eBay or it was sold at Goodwill. How much would someone pay for that used item in that age and that condition? So that usually covers a lot of ground. Now, the next exemption in Virginia available to Virginia residents is the homestead exemption. The homestead exemption is a catch-all exemption. Every resident of Virginia can claim up to $5,000 plus $500 for every dependent they support in any kind of property by filing a homestead deed in the land records where they reside, or if they're claiming an interest in real property where the real property is located. The exemption is increased for persons who are over 65 years of age. They can claim up to $10,000, and a veteran with a service-related disability of at least 40% can claim an additional $10,000 under the Virginia homestead exemption. Again, a homestead deed needs to be filed, and it needs to be filed timely in the bankruptcy case within 5 days of the conclusion of the meeting of creditors in order to claim the property. A good list to use to look at all the different types of federal and state laws that protect property, because there are many other individual federal statutes and Virginia statutes that protect particular types of property. You have to look at a whole set of different laws. A good catch-all form is the Virginia court's website. It's on that website. It's called Virginia Form DC 407, and it's a almost exhaustive list of all different types of federal and state laws that can be used to protect property. It doesn't have everything on there, but it does have many of the different federal and state laws that can be used for exemptions. Another question is, if property is not protected, does that mean it's going to be sold? No, not necessarily. The trustee is only going to sell something if it's of consequential value, meaning the sale of the property or liquidation of the property would actually result in a significant enough amount of money to justify selling it. And this may change depending on the character of the property. Is it liquid or non-liquid? It's a lot easier to tell the debtor to hand over the money in their bank account, or to tell them to give the trustee his or her tax refund, than it is to say go out and sell some tangible property that's not of a liquid character. And finally, liens. The property itself may be subject to liens, mortgages on real property, a car loan against a car, and if these are valid, perfected liens, of course, what would go to the unsecured creditors is, after you deduct the costs of sale and the trustees' commission and any taxes and the value of the lien and any exemption that the debtor can claim in the property, then how much money would be left over to pay to the unsecured creditors for distribution. You can see that the exemption laws are rather complicated. I advise you to consult with your Virginia lawyer to discuss what property might be at risk in your Virginia bankruptcy case.